with liberty and justice for all.
Thank you again to the First District Court of Appeal, who graciously allows us to use this very fine facility. As you probably know, there's some rules for this place, and that is that we only bring in water. So please respect that. Also, as you know, we need to keep your cell phones silenced. And if you are addressing the commission, if you would please speak up so that the recording equipment captures your statements. Also, if you're speaking, I don't think this will be a problem. We ask that you be as succinct as possible so that we can remain efficient this morning, but still give everybody the opportunity to speak. Finally, pursuant to Section 286.0114 of the Florida statutes, we want to remind everybody that members of the public have the opportunity to speak before the commission other than in cases in which we're acting in a quasi-judicial capacity. So this means that the public can have input in matters other than complaints, opinions, and determinations on financial disclosure. So if you do desire to speak, if you will still see Mrs. Fulford, she has a card that you can sign. Millie, will you just raise your hand so everybody knows who you are? So before I continue to preside over this meeting, we need to officially select a chair. So I would ask if there's a nomination for the chair and or the vice chair. You may.
It is with great privilege and pleasure that I seek to nominate our Vice Chairman, Michelle Ankers, as our Chair, and Michael Cox as our Vice Chair for the Commission.
Is there a second?
Second.
Any discussion? I'm going to give you a long time to think about that.
Yeah, especially on me.
How about a point of order?
Somebody protest fast. All those in favor, please indicate by saying aye.
Aye.
Any opposed? Thank you. We'll both do our best. I think I speak on you should hold that till the end and reconsider. At this time, I have to say thank you, and we hope this is not a goodbye to Commissioner Weston. He is what we call the holdover, and we hope that he will continue to serve, but officially his term has come to an end. And Commissioner Weston has been on this commission since I have, which actually has started to be a pretty long time. So he is, to me, a person who's really gained a deep understanding of how the ethics process works. He cares about the principles of those ethics. He's always been articulate in his statements and in his beliefs. I think that we all call him a friend. He's fun to have around. He has a lot of hidden talents. Jacksonville's lucky to have him. So with that, Commissioner Weston, please remember us with this plaque. At this time, I'd ask if I have a motion to approve the minutes from the June 9th meeting.
So moved.
And second, any discussion? All those in favor of approval of the minutes, please indicate by saying aye.
Aye.
Any opposed? Thank you. At this time, we'll move into the guts of the meeting with consideration of final action on a joint stipulation. Will the parties or counsel please identify themselves for the record in the matter of Mr. Kent Reinhardt?
Morning, Tim Reinhardt.
Thank you.
Morning, members of the commission. A pleasure to address you this morning. I'm Wes Gay, attorney with Talon here with Mr. Reinhardt.
Thank you, Mr. Reinhardt and Mr. Gay, for being here. Would you introduce yourself for the record as well?
Melody Hadley, Commission Advocate.
Thank you. Just for the good of the order, we have before us a proposed pre-probable cause stipulation between the commission advocate and the respondent. After considering all the materials and the presentations of the parties, the commission may vote to approve or to reject the stipulation. As this is a pre-probable cause stipulation, if the stipulation is rejected, members of the commission, please recall that we go immediately into the probable cause determination. Complainants have the right to comment in writing on the proposed stipulations, but we have not received any such comments in this case. So with that, Ms. Hadley, would you present the stipulation?
At this time, we bring before you a pre-probable cause stipulation based on the second amended advocate's recommendation. Based on the evidence, we ask that you dismiss allegations 1 and 2. Regarding allegation 3, respondent acknowledged holding private employment within 2 years of leaving public employment with a business entity in connection with a contract which was within his responsibility while he held public employment. As you saw in the stipulation, respondent has taken full responsibility for his actions. We ask that the commission accept the respondent's stipulation that he violated section 112.31854 and recommend imposition of a civil penalty of $1,500.
Thank you, Ms. Hadley. Are there any questions of the advocate? Thank you. Mr. Gay, do you have any comments you'd like to make?
Thank you, members. We will only add that Mr. Reinhardt served as a public employee for 37 years without any complaints. We think that this is a result of an innocent mistake, and it is certainly Mr. Reinhardt's hope that the commission will accept the stipulation that's before it so that he can move forward with his life. Thank you.
Thank you. Any questions of Mr. Gay as he walks away? Thank you.
Madam Chair,
Yes.
I move that we approve the joint stipulation.
Is there a second? Is there any discussion? All those in favor of the motion to approve the joint stipulation, please indicate by saying aye.
Aye.
Any opposed? Thank you. Thank you, Mr. Gay and Mr. Reinhardt, for being with us. The next matter is consideration of dismissal for lack of jurisdiction. As some of you know, this is a case that arises from the law which prescribes that the commission may self-initiate complaints against persons who hold public office or employment and who fail to file a disclosure and received a $1,500 automatic fine. The purpose of the investigation is to determine whether the failure to file was willful, and the only available penalty is removal from office. In this case, the individual has already left public office, and the advocate has recommended that the matter be dismissed for lack of jurisdiction. Would any members like to hear from the advocate, or would I hear a motion?
Madam Chair, I move for approval. Second.
Any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. We also have a consideration next on the agenda of dismissal due to the death of the respondent. This is a case, just by its very nature, that we may consider differently because the respondent has passed away. Once again, I'd like to ask if any members would like to hear from the advocate, or if you have a motion.
Madam Chair, I would move for approval of the motion to dismiss.
Second as well.
Second. Any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Thank you.
Thank you.
Thank you especially for your work on that, Ms. Miller. I know that was a difficult and long case, and we appreciate the effort that went into the motion and the history of that case.
Thank you, Madam Chair.
We have kind of rearranged the agenda a little bit on the advisory opinions. File 2696 has been continued, so we have two other advisory opinions today. The first of which is 2697, which will be presented by Attorney Betsy Daly. Is the requester here? Mr. Schoenwalder. Would you introduce yourself?
I'm Timothy Schoenwalder from the Mead Law Firm.
Thank you for being here, Mr. Schoenwalder. Ms. Daly, would you present?
Thank you, Madam Chair. This opinion was requested by an attorney on behalf of a former Chief of Staff of the Florida Department of Management Services. It concerns post-public employment restrictions. Beginning in 2012, the former employee held several senior management positions at the Department of Management Services, and most recently he was the agency's Chief of Staff. Since his departure from DMS in May 2016, he's worked for a company that develops software for DMS and other Florida agencies. His present employer has 2 DMS contracts awarded while he was still at the agency, and 2 other contracts awarded after he left DMS. The draft opinion concludes that the former employee's present employment is in compliance with the post-employment provisions of the Code of Ethics. The first provision, 112.313.9a, prohibits a former senior management employee from lobbying his agency for 2 years after departing the agency. but the former employee states he does not intend to represent his employer or any other client or entity before DMS during the rest of the 2-year period that began when he left DMS in May 2016. As long as he sticks to this intention, he will not be in violation of 112.313.9A. Section 112.31853 prohibits a former agency employee from ever working in the private sector on a contract that he helped to procure while a state employee. This provision does not apply in the former employee's situation, since he states he was not personally and substantially involved in contract procurement at DMS. And third, 112.31854 states that for 2 years after leaving his public position, a former agency employee cannot be employed in connection with the contract for contractual services for which he had some responsibility at the agency. But here, the former employee states he did not supervise the performance of DMS contracts for contractual services, and he had no discretionary responsibility as to contract performance. So, under the facts presented, this limitation also does not apply to him. The draft opinion is offered for your considerations. Mr. Schoenwalder or I will be glad to address any questions.
Thank you, Ms. Daly. Before we ask for any other comments for Mr. Schoenwalder, does any member of the commission have questions for Ms. Daly? Commissioner Brady.
So the role of the chief of staff is not regarded as senior enough to really present a potential conflict? Or is it just because he's not involved in procurement directly that it's not a conflict?
Well, Section 3185 is very contract specific. And so under the facts that he presented to us, he did not work to procure or have any responsibility over any of the contracts that his present employer has.
Any other questions? Mr. Schoenwalder, would you like to present or make any statement?
Madam Chair, I would only suggest that I'm very pleased with the analysis that the commission staff offered. And we would look the staff to their recommendation to be accepted by the commission.
Thank you. I would entertain a motion regarding this opinion.
Move to approve?
Is there a second?
Second.
Any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? Thank you. Thank you, Ms. Daly. Thank you, Mr. Schoenwalder. The next file, 2698, will be presented by Mr. Chris Anderson. May I ask if the requester for this opinion is here?
Yes, Madam Chair, I'm here. Thank you.
Thank you. And your name?
Melinda Miguel.
Thank you, Ms. McGow. Mr. Anderson.
Thank you, Madam Chair. This opinion primarily has at issue Section 112.31853 Florida statutes, which is one of the statutes that was at issue in the opinion just discussed. And this statute goes to a person having been involved personally and substantially in the procurement process while they were a state employee, and therefore not being able to work in connection with a particular contract if they were so involved. In this case, although Ms. Miguel had a role tangentially in regard to a particular contract that she would seek to work privately for now after leaving state government, her role was not a procurement role. She did not design the contract, did not do any of those things that trigger the statute. Rather, she was in a collateral position of reviewing things as Chief Inspector General. And just frankly, under the facts of the matter, it does not trigger the elements of the statute. The opinion also goes on to say that there are several other statutes that are not triggered by her situation either. They're not treated extensively in the opinion like 112.3185 subsection 3 is, and that's because they really didn't need extensive treatment. It's apparent from the fact pattern that they're really not at issue at all. So this draft is offered for your consideration, and if you have any questions of me, I'll be happy to try to answer them.
Thank you, Mr. Anderson. Any questions of Mr. Anderson? Thank you. If not, Ms. Miguel, do you have any comments you'd like to make?
No, but thank you very much, Madam Chair, members of the commission. I appreciate the opportunity to be
while we're in the thank you mode, I'd like to thank you for asking for the opinion in these particular circumstances. You didn't necessarily have to do that, but I think that it was helpful to the process and to us to have the opportunity to review the facts and apply the law the best we can. If there are no questions, I would entertain a motion on this opinion.
Madam Chair, I move that we approve the recommended opinion.
Is there a second? Any discussion? All those in favor of the opinion, please indicate by saying aye, or in favor of the motion. Any opposed? Thank you. The next matter on the agenda is the consideration of financial disclosure appeals. These are the appeals of the automatic fines under the financial disclosure law. And first, we're going to take up one that is an appeal for which the appellant has requested a hearing, and then we'll consider the other appeals together. Is there anyone present who's requested a hearing before the commission on a financial disclosure appeal? Thank you, Ms. Milford. Mr. Knight, you're up for this. If you would please make your presentation.
Thank you, Madam Chair. The respondent in this case was a member of the City of Gainesville Development Review Board, which was a position that required filing of CD Form 1 for the year 2015. The Alachua County Supervisor of Elections sent the respondent notices of his obligation to file. The second notice sent by the Supervisor of Elections was sent by certified mail, and that notice was returned by the post office marked return to sender, not deliverable as addressed, unable to forward. Then on August the 17th, the commission mailed the appellant a postcard, and that also was returned by the post office marked return to sender, vacant, unable to forward. And on September the 7th, the commission mailed the appellant a notice, which was also returned, marked return to sender, not deliverable as addressed. So all of the notices sent by both the supervisor and the commission were returned as being not deliverable. Finally, on May 1st, 2017, the appellant submitted his form to the Alachua County Supervisor of Election and submitted his appeal to the commission. In his appeal, the appellant claimed that he failed to timely file his disclosure form due to lack of notice. He states that all of the notices regarding his financial disclosure obligation were mailed to his previous addresses and were not forwarded to the post office box that he currently used as his mailing address. The appellant submitted documentation to verify these claims of his, and as a result, we recommend a waiver of the automatic fine of $1,500 that was assessed against him.
Thank you, Mr. Knight. Are there any questions of Mr. Knight? And I don't believe there's any comment because Mr. Kane is not here. If not, I would hear a motion if there is one.
Move to approve the recommendation of staff.
There's been a motion to approve the recommendation of staff on the final order. Is there a second?
Second.
Any discussion? Hearing none, all those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. On the next set of the financial disclosure appeals, is there anyone who would like to take any one of these matters separately?
Just wanted to point out for the record that number 6 was FD 16075 Patrick McRae out of Fort Pierce. I've tried several cases with him when I was a state attorney. He was in private practice and a public defender. He was a public defender as well. And I run into him from time to time, but I don't see any conflict in me voting on that case. I did want to disclose that for the record.
Thank you. Commissioner Berger. Mr. Anderson, you have no concerns or comments regarding that?
No, Madam Chair, I don't think that rises to the level of a required abstention, but do appreciate the candor.
Thank
Thanks.
you. Yes, Commissioner Brady.
A question for the executive director. In reading the no hearing, on some occasions, people tell us, oh gee whiz, the dog ate my homework, and we ask them to demonstrate that the dog ate their homework. Is that at the discretion of who's ever making the request?
Well, typically.
There's one where somebody's sick and said, I stayed with my mother and father, and basically, we said, well, can you prove that? And we just never heard anything back. I mean, is the staff just do that when they look through the various petitions or orders?
Through the chair, the staff typically asks the appellant to back up whatever claims that it is he's making, whether it's the dog ate his financial disclosure, which actually, that you laugh, but that
Yes,
actually
if you
has
laugh.
been a defense one time. So they ask for whatever information that the appellant has. Now, these are not formal hearings under Chapter 120, so we basically take the information they provide us as true. You know, the facts are undisputed, so, but we do ask for them to back up whatever claims they're making.
Thank you. Any other questions? If not, I would entertain a motion that we adopt the remainder of the financial disclosure appeals in Moss.
So moved.
Second. Any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? Thank you. The motion passes. As we move on to item 10 on our agenda, this is the consideration of an order and request for an extension by the chair. As the chair, I'm permitted to give extensions up to 45 days, but only the commission can grant a longer extension. So in your materials, you have a draft order. If there are any questions, I think Mr. Schaefer's prepared to answer them. If not, I would entertain a motion. I'm sorry, Mr. Berger. Thank you. Motion to approve the extension. Is there a second?
Second.
Any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? Thank you. The motion passes. The next item on the agenda, 11, are final orders, on financial disclosures where fines where there has been no appeal and no payment. Item 11 specifically includes persons whose disclosure statements were late filed, not filed at all, or who did not appeal the assessed fine or pay the fine. These cases are also before you for the adoption of final orders imposing the fines. Are there any questions from the members? If not, do I hear a motion? Motion to approve the financial disclosure fines as presented. Is there a second? Any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? Thank you. The motion passes. We're now to the proposed meeting calendar, which staff was kind enough to present in advance. Presuming that everyone's had a chance to look at this for 2018, it not only sets forth the actual meeting events, but it also sets forth the deadlines. Has anybody identified any conflicts with the proposed meeting dates? If not, I would entertain a motion that we adopt this as the meeting schedule.
So moved.
Second, and I would just ask that the executive director send out just the meeting dates to us.
Yes, sir. Let's see. Good idea. All those in favor of the motion, I'm sure it was seconded by somebody. Commissioner Cox, all those in favor, please indicate by saying aye.
Aye.
Any opposed? Now, although we've moved at great haste so far, it all comes to a crashing end right now because the next item on the agenda is a discussion of legislative proposals. As most of you know, we've had this discussion before. We are required by law to make recommendations for any changes we think would improve the ethics laws. And I've asked Ms. Doss if she will briefly go over the legislative issues that she's compiled. Then we'll hear from any members who want to make comment on that. We'll also ask if there are many members of the public who might have suggestions on this package. And after that, we'll take a vote.
Thank you, Madam Chair. I'll preface my remarks by saying I'll do my best to keep it brief. In addition to selecting the items that you want in your legislative package, I'm hoping to get your direction in a few other areas as well. It would be helpful to know if you would like to have a legislative liaison again this year. I am authorized to represent that Commissioner Carson, although he's not here, is willing to assume that post. although I feel a little bad volunteering somebody for something when they're not here to defend themselves, but I did speak to him and he's
Best
willing
way
to
to
do
do
that. Also,
We've done it to you.
I'd like to get your feeling on whether the liaison can speak for the commission. A lot of times things come up at the last minute, and obviously the commission only meets once every 6 weeks. It's very helpful if the liaison can kind of make that call. It comes up a fair amount of time, but I wouldn't expect this to be something that is a routine matter. You know, there are a lot of bills that come through that it's really, I can represent to staff of the legislature that I can't imagine the commission having a problem with this, or it's just a really pure policy issue. But last year, the motion, there was a similar motion regarding the liaison, but it was a little bit ambiguous about whether he had the ability to speak for the commission, and I'd like to get some clarity on that. I'd like to get a feel from you, and you can be chewing on this, I guess, as I kind of go through the recommendations, but on how robust you want our efforts to be. We've kind of limited ourselves to just talking to staff and members. When Chair Carlucci was legislative liaison, we had some letters to the editor. Those were very effective in, I think, getting some things moving and improving some things. In 2013, when there was a lot of ethics legislation going on, Integrity Florida had a press conference where they pointed out some real significant shortcomings in the blind trust law, which had initially come at our recommendation, but as drafted at the time, had some serious problems. And that was very helpful. We've never done anything like that, and I hesitate to do anything like that without making sure that that's kind of the direction that you are willing to go. So be thinking about that. And last but not least, there's an issue in the package that I'll get to last that the commission has voted in the past to oppose that is contrary to a long history of commission opinions. And if you're still feeling the same way, I'd like to get your renewed ratification of that opposition. So with that, I'll just speak to the issues really briefly. There's been actually a little bit of movement on some of these. Number one is the burden of proof. The commission has in the past recommended that it be preponderance of evidence versus clear and convincing. It was preponderance of evidence for more than 20 years until a court case changed that. It's obviously harder to make the clear and convincing evidence standard, and honestly, I think some of the administrative law judges see clear and convincing as being much closer to beyond a reasonable doubt. Having said all that, I've never seen any interest in that from the legislature whatsoever, and so if you're looking at things to streamline, that might be one that you want to leave out this year. Conflicts of interest, this is a loophole closing measure. It got a lot of interest last year. It was our number one priority in 2016. It was picked up in a House bill last year, but never got anywhere in the Senate. But I have heard from a senator from Miami-Dade, Senator Rodriguez, who is interested in this and some of the other aspects of the bill, and may be willing to sponsor that for us this year. He hasn't made any commitments, but he's at least expressed interest. The attorney fees issue, this, in my opinion, is a really significant and necessary leveling of the playing field. I think the motion came last year from Commissioner Norris on this. There hasn't been very much interest in it from the legislature by and large, but again, I believe this is one of the ones Senator Rodriguez was interested in, so it might be able to get some traction this year. The enhanced financial disclosure for local elected officials. This is a really good idea that originated with Commissioner Cox, having municipal officials file Form 6 versus Form 1. And I think the impetus was governing board members. I found out that there are some municipal officials, like sometimes police chiefs are elected or whatever, but I think it was directed at the municipal board members. This is a very simple and elegant idea, which was picked up last year and kind of morphed into a very complicated plan under which municipal officials in cities that had more than $10 million in revenue for 3 years in a row would file Form 6, but if their revenue dropped below $10 million for 3 years in a row, they'd go back to Form 1. And so this is, there's a word for it, it's called differential accountability or something. It's very common, I found out, in education issues. You know, if a school is failing for 3 years, then this happens, and if it's, well, but you know, the Department of Education has a big building full of people in it to keep track of that stuff. Philosophically, I think there's some issues. If you're in a poor municipality, you kind of have the right to know as much about your officials as you do if you're in a rich municipality. But beyond that, in complete candor, I'm afraid we would not be able to keep up with that changing standard, and we would at some point give somebody the wrong advice or send them the wrong form. I just have a real concern about a staff this small being able to keep up with all those municipalities. So I think the simple, elegant idea that Commissioner Cox has was great. Having said that, a lot more work for your staff. It would be like 2,500 more Form 6s coming in. But be that as it may, it's just a really good public policy idea. So
My comment on that. Or you want to wait till?
Why don't we go through all of them, and then we'll pick back up comments. Thank you.
The voting conflicts law, changing for local elected officials. This would require local elected officials to disclose their conflict before they participate in the discussion on the vote, which currently they are not required to do. Last year's bill picked that up as well in the House. The other voting conflict issue was to bring the state level appointed people to the same standard that applies to local government officials. Meaning, right now, state level appointed and elected officials only have to abstain when the measure inures to their own special private gain or benefit. Local officials have to abstain if it inures to their benefit or that of a relative, business associate, employer, etc. So this would bring appointed officials at the state level to that same standard. The commission, I think, intentionally left out elected officials because it would reduce the chances of it getting passed because, of course, the legislature's elected officials. Having said that, a lot of people think that, you know, elected officials might need to be included too. These are another area where the senators expressed some interest. Applying the ethics laws to privatized government functions. This came from Commissioner Brady, another, you know, I think really good idea. These privatized companies are doing the same work that state employees used to do, yet they're not subject to the ethics laws, and there's a lot of money involved. This did not get much attention or interest last year, and the rationale that I heard for that is that state agencies have to contract with these entities, and if the state agencies want to, they can put ethics provisions in their contracts. They can do that. Another alternative would just, or a thought that was raised actually when I was talking with the senator the other day would be, I'm sorry, I don't want to misattribute that. I was talking to someone. I've talked to a lot of people about this. But the idea came up, well, maybe the law could just be changed to require the agencies to put that in their contract. So there would be some options there. I did some draft. I took a stab at drafting on virtually all of these. This is a particularly hard issue to draft, and I left a lot of the underlying law in there just so you all could get a feel for what that all entails. And then last but not least is the issue of that the commission has historically opposed. The commission has in many, many, many opinions said that the conflict of interest law would oh, I'm sorry, I think I left one out. Self-initiation.
Yep.
Yeah, I'm sorry, I skipped a couple. Sorry, that privatization one was so long, I thought I was at the end. Financial disclosure, these are things that would be cleanup. They would streamline the process a lot. They would allow us to be much more efficient honestly, nobody, they're kind of arcane and nuanced. Nobody in the legislature has expressed any interest whatsoever. That might be another one if you want to streamline your proposals that you want to think about jettisoning, because I don't think any of those are going to go anywhere. Self-initiation is not something that was in your recommendations last year, but it has been many times, and so I included it in there so that you could have that opportunity if you want it. And then this is the last one, the one the commission has voted to oppose in the past. Okay, your long line of opinion says, under the conflicts law, if you sit on a board, like the Ethics Commission, you can't represent clients before that board, and neither can any member of your law firm, your engineering firm, your architectural firm, your professional firm. It's really similar to a rule in the Code of Professional Responsibility for lawyers. It says if you have a conflict, then every member of your firm has a conflict. This comes up fairly frequently in the legislature. There are a lot of lawyers out there, as you may have noticed. There's a lot of lawyers sitting on board who are very active in public service, and a lot of lawyers would like for their firm members to be able to represent clients before their boards. The commission voted to oppose that, as I said, in 2015. It came up twice in 2015. The commission was against it, and the legislator took it out of his package. Last year, at the very end of the session, a measure that would have undermined that line of precedent was introduced. Fortunately, I knew that the commission was opposed to it because it had voted on that exact issue. But if that had not been the case, that would have been a good situation where the liaison could have made the call. The House was very opposed to that, to changing that line of precedent. And when the bill went to the House, they stripped off that amendment and it went back to the Senate and it passed without the amendment. But I think it's likely to come up again, and so assuming you still feel the same way, Commissioner Carson and I worked really hard on that at the very last days, and he was tremendously helpful. So, since it's been 2 years since there was any vote on it, I'd appreciate if you'd ratify that, assuming you feel the same way. And I'm happy to take any questions.
Thank you. Members, if agreeable to you, I think it might make the most sense organizationally if we start at the beginning and see if anybody has any comments or questions on the first proposal and then take them one by one.
If I
Commissioner
may.
Weston.
Yes, is it appropriate for me to ask if, among all of these possible recommendations or efforts, does staff have a particular area that they would like us to focus on before we actually go through the list so that we can hone in on some of them? I'm just asking.
I really don't. The two that I think aren't going to get anywhere, I think probably would be appropriate to take out of the recommendations, but the other ones are all really valuable, I think, and would really make good changes in the law.
Okay, there's nothing that's more pressing than the other in your view then, as far as you know?
No, I'll say the conflict of interest provision, the commission, that was the #1 priority in 2016, and it's really been something the commission has seemed to feel strongly about. I think it's really a good idea and really necessary, so I guess if you had to name a #1, that would probably be it.
Thank you.
Thank you. The first legislative proposal, and I'm going by the package in our materials, is referenced as the burden of proof. This is one of the ones that if we were going to streamline, staff recommends that we omit. Is there any objection to omitting this? Only for efficiency purposes, not because it's not a good idea. I think most of us probably agree it's a good idea. Commissioner Cox?
I don't have a problem in omitting it, but what I'd prefer to see us do is to propose it as an additional type of thing, just so that we're on the record of saying we believe this is a good idea, and to put it forth. But I wouldn't put it in our top 3 priorities or whatever.
Does anybody have any concern just on the substance of changing that standard? if we're in agreement regarding the standard, then I think what Commissioner Cox is saying is that we include it in the package, but that not be a primary issue of advocacy from staff. Is that accurate?
Loses its title as number one.
Yes. Drops down to the bottom. Any objection to proceeding that way? Thanks. If not, let's move to number 2, conflicts of interest, which I believe is one of the ones that has some priority. Any comment or questions regarding that?
I think that's a good one that we should continue to pursue as our lead, if that's at all possible.
Any objection to keeping the conflict of interest proposal at the higher part of our advocacy's agenda?
I think it should be number 1.
Until we hear otherwise, we'll put that at number 1. If we need to toggle those around as we go through this, we can reconsider it. Number 3 is attorney's fees. Again, something that I think we have an interest in. According to Ms. Doss, it hasn't really captured the attention of the legislature. We can keep it on our list, but not necessarily keep it in the top 3. Commissioner Norris, I'd call on you just because you had a special interest in the issue if you have any comment. If not, we can proceed as I suggested.
I like moving it up the list, and hopefully we can find a great legislator.
So
If I may, do we, I guess it really doesn't matter, well, I guess it does matter to a certain degree. If we push for certain things, we don't want to possibly alienate the legislature, I guess. I'm just thinking out loud with you. By maybe making suggestions that we know that they're not going to consider. And will that take away from the more salient ones that we are concerned about? That's just a question generally for the commission, not suggesting that that's what we should do.
I'll let Ms. Doss respond.
I can answer that. Our typical process is Carrie, she's the other lobbyist for the commission. She and I go over and meet with staff in the Public Integrity and Ethics Committee and in the Ethics and Elections Committee in the Senate. And we lay out the whole thing. It's like a smorgasbord of delightful, bountiful gifts. Then in the House, at least, there's a committee bill, and they pick up the ones they like, and the ones they don't, then they don't.
Okay.
And sometimes there's an individual sponsor who picks up some of the same ones that were in the committee bill, or maybe some of different ones. They don't, I think sometimes they get overwhelmed with the length of the list, but they don't seem to be miffed by,
Okay.
suggesting
Okay.
things that they're just not going to be interested in. They just don't pick them up.
Thank you.
Yes.
My thought on this is that the commission has an obligation to advocate a standard. And we need to be very clear about that, and we need to be very consistent as best we can about that. And in doing so, we, recognize that on the whole, we've got a very good ethics code in the state of Florida. That experience tells us and shows that there are certain places where it could stand a little tweaking. So we just recognize that it's a aircraft carrier that moves in turn very slowly, and so I think that's why consistency is important. And I think that anything with regard to these matters, it may be wise to try to approach individual legislators, particularly obviously those that are in present leadership, but maybe some of those that are designated leadership 4, 6, and 8 years from now, and start having them be the focus of the effort to, this is why we think, number 1, it should be the standard, and number 2, why we think it's a good idea, and number 3, why we think that you, Mr. Legislator, ought to be an advocate for it. And then let them carry the water on doing that, hopefully, and if not before they get into those positions of leadership, by the time they do.
Well said.
Yeah, that's a good point.
Stas, do you have any response to that? Otherwise, I think you understand the
No,
message of,
I think that's really an excellent idea. I think that's really an excellent idea.
thank you, Commissioner Norris. Thank you, Mr. Squirrel. Number 4 is enhanced financial disclosure for local elected officials, and I'd like to give the floor to Commissioner Cox. If you have any comments, this is the one that you might have had a particular interest in last year.
Yeah, I just have a belief that if you put yourself out to whatever entity it is to be elected, to be entrusted with the public's trust, whether it's a big organization or it's a small organization. I've had the privilege of being elected in both a very small town and a pretty sizable county. I don't see the distinguishing difference between the fact that I was the mayor of a small town versus a commissioner in a large county. The same dynamics and conflicts are in both, although they may be of different scale. It's important, though, to the people who are affected by that. So my thought is that the law should say that if you hold an elected position, you should file Form 6. Not this convoluted, based on the size of the city or the municipality or the entity. You should file Form 6. So that's all I would like to see done. And they have to file Form 1 anyway, so that's not a impact on our staff. Correct?
Yeah, actually it is, because currently they file Form 1 with their supervisors of
Oh,
elections.
right.
All Form 6s get filed with us. But,
That's right.
we're willing to absorb that workload. The bottom line means that the Form 6s, which we have to post on our website, that's where really the time consuming.
Right.
We won't be able to get that done as quickly as we do now.
Okay.
But, the philosophical concern, I think, is worth the extra workload. So I would not hesitate on those grounds.
Maybe compromise there if it's an issue. I'm not hearing that it is an issue, but if it were a time constraint issue, could there be verbiage placed that would allow those individuals to continue to file with their supervisor of elections that Form 6? I mean, it's in the public. That's really all I really want, is for it to be public information.
I really kind of feel like Form 6s should be filed with the Ethics Commission.
Okay.
And, we can hire OPM. We'll figure out a way with the workload. What I'm hearing, just so that I can be clear in the message I bring to the legislature, is that you all feel strongly that all municipal elected governing boards should file Form 6, period, and are not in favor of any kind of fluctuating standard.
Let me just make sure I know that's the viewpoint of some by nods of head. Is there any concern or objection to that principle of having municipal elected officials regardless of the size of the community? Commissioner Berger.
Executive Director, so practically speaking, what we're talking about is uniformity across the board, and we're willing to take on that burden.
Yes.
That's what we're saying.
Which I think is quite a message to deliver, that we are working against ourselves in terms of workload, but we believe it's in the best interest of the state and strong public policy to equalize the obligations. And I think it's an honorable move to make. If they don't choose to grant it, I think that we've at least volunteered. Thank you, staff, in advance. We'll try.
If I may, on that subject, which is another pet peeve of mine, if we could electronically do this, then that would streamline the whole issue. If people could electronically file their Form 6.
The workload comes in redacting them and putting them on the website. That's
Because of the addresses.
That's the labor-intensive part of it.
Yeah.
I still believe that day will come.
Electronics
You may
ought
not
to
be
be
alive.
able to do that.
Any other comments on that particular issue? If If not, let's move to number 5, voting conflicts law, local elected officials. Any questions or comments?
Personally, I think that the local elected officials and the state elected officials should just be treated the same. I mean, you
Is
know,
it kind of the same
instead of
sentiment?
being different.
Same sentiment as the last one. Is there any objection to mimicking that message that we had on the last proposal and applying that to this one?
No.
If not, then we'll proceed that way. Ms. Doss?
I have a question. Appointed, in addition to local and state being treated differently, appointed and elected are treated differently. Do you also feel like they should all be treated the same?
Yes.
Yes.
Any other? I think you have pretty, at least consensus, if not unanimous.
There's no, I'm just trying to figure out what's the rational basis for the distinction anyway. I mean, I just don't. You know what I'm saying?
Who's making the decision?
Yeah, yeah.
I believe that was number 6. Is that right, Ms. Doss?
Yes.
Voting conflicts. So we'll move on to number 7, which is applying the ethics law to privatized government functions. Commissioner Brady, would you like to make any comments, as this is one that you had some input in?
No, I mean, it's just that what's really occurred over the course of the last 20 years is that we have taken large amounts of state money that was contracted by state agencies, where the individuals responsible for doing that and making those decisions were covered by the ethics law. And as we saw in an advisory opinion today, that we take that very seriously in terms of making certain that those people do their jobs and don't violate the ethics law in the performance of their jobs or when they leave their jobs. And we give these to private nonprofit corporations, which, to be candid, are not subject to the ethics laws, though on occasion they adopt ethical standards. As someone who has watched these boards over the years in South Florida, a lot of conflict of interest, relatively low transparency, and a real need to say that we need to standardize across the state how we address those things in terms of things like conflicts of interest, in terms of disclosure of interest, and in terms of having a better understanding of what people do and don't do in agencies that handle hundreds of millions of dollars on a regular basis.
Any other comments? Commissioner Weston?
I agree that, particularly with Commissioner Brady's experience, and he's over the years he's had an opportunity to see how these things work. The only question I would have is, we know that some state entities the ethics code doesn't apply to all the ethics code doesn't apply to every single entity. I mean, they have certain things. So we would have to then, it seems to me, figure out exactly what portions of the ethics code that's more relevant to these private companies, because obviously some of the things may or may not relate, it seems to me. So I don't know how to actually address that up front, but it seems because we had either a case or opinion a couple of meetings ago where, the ethics, the state said, well, exempted them from certain parts, and it clearly made them a part. So we got to figure out how we do that, it seems to me. I'm rambling, but I think you get what I'm
Well,
trying
let
to
me
say.
ask Commissioner Doss, the Honorable Executive Director Doss.
Big pay cut.
Mrs. Doss struggled with crafting the legislation that is the proposal for this issue. Do you, since you've been through that struggle, do you feel like we have addressed that in your draft, or do you feel like that's something that might need more attention?
Yes, to both. It is a hard drafting issue. The way I drafted it was that the officers, partners, members of the board of directors, members of the limited liability company, and chief executive officer would be covered by the entire code of ethics. The employees would not. That would be something that I'm sure may be likely to change during the course of the legislative process. And so you're not exactly sure precisely what you'll end up with. Commissioner Weston is exactly right. There's, Citizens Insurance out there, other kinds of organizations, and some of the people, but not all of the people, are covered by some of the provisions of the code, but not all the provisions of the code. And that's something I'm sure would get a lot of attention in the in the process as it goes through. The way I just started out was just to have those people at the higher echelons covered by the entire code.
Ms. Doss, I wondered if we are required to actually provide statutory proposed language, or can we just present the concept? In this case, I know you did it at least to help us envision what a law would actually look like and how it might be applied, but what is your standard for that?
We're not required to, and the legislative recommendations go in the annual report, in our annual report. No draft language goes in with that. I'm routinely asked by staff of the House and Senate, do you have language? And so I give them some as a starting place.
But it's not necessarily included in our report, the draft language.
Oh, no, it's not included in the report at all.
The reason I mention that is because to me that's a way of presenting the idea but not being called upon to deal with some of the specific but valid questions that Commissioner Weston's raised. And frankly, we leave some of that to the sausage-making process a little later down the line.
Well, I'm sorry.
Go. Let me ask Commissioner Norris.
Well, I believe that we've had discussions about this sometime last year or even before, where when we were talking about our recommendations, we wanted to have proposed language, and I think the executive director did follow up with doing what we really wanted her to do, and this is why it's, of course, at least from my memory.
Right. I think it's helpful to have. It's just not necessarily at the stage on a new issue like this that we're quite ready to advertise it up front, but we have it there as backup. Commissioner Norris.
Well, it's only appropriate for her to do all that work and then for us to complain about it. You can swear like they should be. Our executive director mentioned in her first remarks on this concept, I think of something being added to the contracts about it. Can you expound on that just a little bit?
Yes.
Really get it first time through. So what does that entail?
When Carrie and I met with legislative staff last year and we raised this issue, one of the remarks that was made was, well, the Department of Children and Families contracts with these lead agencies, and so the Department of Children and Families could put provisions in their contract that said, you lead agencies, you got to comply with the ethics laws and accomplish it that way. So I just kind of extrapolating on that, I suppose one way of approaching this whole issue would be to have statutory language saying that the state agencies are required to put in their contracts that the lead agencies will be bound. Now, I have not talked to any state agency people. I don't know. Usually things sound simpler in concept than they really are in practice, so there may be reasons why the agencies wouldn't want to do it and reasons why they haven't done it so far, but that's another way of looking at that issue. But that was kind of the feedback that we got from staff. This law is, it's not really necessary to change the law because the agencies can just put that in their contract if they want.
Commissioner Brady.
Yeah,
Excuse
I mean,
me.
I understand that, at least in the case of the managing entities, that there's apparently a provision that the managing entity adopt an ethics code and that the ethics code be disclosed to the department. I was on the board of the managing entity from the day it was created up until 2 years ago, and I can tell you, I never remembered voting on an ethics code, and I paid a lot of attention to that. So I think what occurs is that you end up with different standards existing for different agencies that really have the same statutory basis because everybody deals with it a little differently. And this is really an opportunity to kind of say this is the expectation in terms of Florida's ethics laws, and we intend to have people that really spend large amounts of public money abide by them. But I understand there are some contractual languages.
Thank you. Commissioner Norris.
Well, from macro, larger approach, one of the concerns I have about this is you know, with privatization, I'm not a, you know, an advocate of a high regulatory environment over private business. And this kind of thing, I believe, accurate, would apply not only to some privatization company that's a very large company with a board of directors and what have you, but all the way down to a single member limited liability company that you know has one person acting as a contractor contracting with various agencies and such. And it seems like to me that of course in the concept of that those contracts, virtually by virtue of being a private company, everything that they're voting on has a special pecuniary gain as part of the issue that they're voting on. So I think from a practical standpoint, application of this would be tremendously difficult. I understand the ideal, and I'm in favor of the ideal. I just don't know exactly how it could possibly get, how it gets implemented effectively. And so to the extent that it does, it seems to me that maybe the concept of including in the contract, one of the things the legislature did, time gets on by, I mean, get to be an old man, I think it was 2 or 3 years ago, where each contract with private companies is supposed to have a particular paragraph in it about their requirements to comply with public records laws with respect to the contracts they have with government agencies and subject to public records requests, because you know private companies would get a public records request about their public contract that will listen, apply to us and not respond to it. So I don't know what I guess I'm turning into a politician. I've got good questions, but just don't have any answers. So I'm not sure what the answer is on that, but those are my concerns, is how would that ultimately be implemented through the ethics code, and I'm not sure that's the place for it.
Any other comments or questions? I think this is a tricky one in terms of what direction we give staff. It sounds like there's some interest, Ms. Doss, in being able to articulate to the legislature and their staffs that this is an issue of interest that may be more in the mode of something that is a recommended standard that agencies begin to include, but maybe making it discretionary, moving it up slowly on the hierarchy so that at some point it's recommended, which is more than it is now, and then later strengthening it perhaps to be something that's more mandatory. Commissioner Berger and then Commissioner Brady.
I was just going to ask since I'm not an attorney, as a question of law, can you compel somebody to basically abide by a statutory standard which they're not mentioned in?
Well, I'll try not to practice law right now. I'm going to ask Mr. Anderson if he'd like to practice law right now.
Thank you, Madam Chair. That's kind of been on my mind too there. I think probably what you would have would be contractual enforceability of the standards rather than, I don't think by a contract you can amend the statutes of the state. But the statutes could require things to be put in contracts. I have some concern as to whether or not the commission could enforce that through the complaint process. It might have to be a contractual breach of contract action by the state agency against the private company for deviating from the substantive norms of the code of ethics that had been made part of the contract.
I think what I'm considering is actually something aspirational, not mandatory. And I've seen it surprisingly in statutes where a statute might recommend a mediation process. It doesn't mandate the mediation process, it recommends it. It's surprising that that's in a statute, but it really ends up being nothing more than a recommendation. Commissioner Berger.
I guess it's more of a question for our attorney and executive director, unless I'm getting a little confused on the issue. It seems to me, to a degree, the authority to do this is already there, but regards to
The-
the contracts.
Presumably, and I'm not a contract lawyer by any means, presumably the state agencies currently have the ability to put language in their contracts that says, if you want to be our managing entity, then these members of your corporation must abide by the code of ethics. I think Mr. Anderson's right when he says if they don't do that, it'd be a contractual issue and not something for the Ethics Commission to enforce. But if the agencies have the ability to do that, there may be reasons why they're not already doing that. I mean, I don't know how hard the competition is among the managing entities, but if there's not a lot of competition, then they might have more bargaining power, and if the agencies put that in there, they'll say, well, fine, find somebody else to do it.
To the best of my knowledge, that's never happened.
No.
But my knowledge is not complete.
So in reviewing Ms. Doss's introduction to this proposal, she mentioned that there has not been any legislative interest in it. At this point, given that we really don't even have a person that is willing to carry the water on it, and we have really, I think, a bit of lack of certainty and confidence in this at this point, is there any objection to leaving this one off the proposal for this year, but allowing Ms. Doss to present language if asked as she's prepared it? Any objection to that? Okay, thank you for all your work. And it probably will continue to be used as we move forward and perfect it. Number 8 is financial disclosure. It's on page 26 of your package. Again, these have not apparently generated very much interest. Just keep that in mind as we enter into our discussion. Is there any comment or questions on this one? Hearing none, is there any objection to leaving this one off the list? Mrs. Doss, do I understand that that would be one that you would recommend omitting to streamline and give priority to the others? Is there any objection to omitting that one? Hearing none, let's move to number 9, which is self-initiation.
Well, that is one that I've always had my little soapbox on. That from the outward appearance as you look at it, it sounds to me like a great idea. But the more you, in my view, the more you think about it, though, and I know some of my members here don't agree with me on this, that I don't want us necessarily. It seems to me that with the state attorney, the governor, the number of people out there that can actually file complaints as it is, being self-initiators, to me, sounds like being, everything. So I just think I just feel uncomfortable when you're charging, when you're deliberating, and when you're judging, and you're being the sheriff, you're being everything, and so to me, it puts us. To me, it would kind of sully the reputation of independence and impartiality. Although I know a lot of places have it, I know counties have it, cities may have it, but to me, if the commission were to self-initiate, well, of course, if we self-initiate, we want to make sure that we do it the right way. But it seems to me, again, I just don't feel comfortable with that aspect of it, although I understand it's a good idea.
Last year, I recall we had some healthy discussion on this issue, and we ultimately decided not to include it in the package. I just want to offer that to refresh the memories of those that were here and inform those that weren't. Any other questions or comments on this one? Commissioner Cox?
Well, I will say when it was included, I had a conversation with a couple legislators, and it really irritates them when the commission is asking for that power. So, I have to think to myself, does that, us asking for that and their disdain for it affect some of our other priorities that we are, more passionate about. I'm thinking that we shouldn't fight that fight.
It's probably a good suggestion, Commissioner Berger.
I didn't have the privilege of being here last year to hear the discussion, but when I think of how this would work in theory, who's the complainant, who's the witness, is it us? And it just, is there going to be a conflict of interest because we're the witness, complainant, whatever? I agree with Commissioner Weston. It just, it's rife with issues and problems.
I think you've identified some of the issues that were raised last year. Yeah.
We don't have any shortage of cases either.
Right, and I think that we've invited some more work on something we believe more strongly in, and this is one where we might balance ourselves out and not take on an additional burden. So if there's no objection, we'll leave that one off of our package and move on to the last one. This is the one that regards appearances before the board by board members' firms, colleagues. And if you recall, this is one in which it would be consistent with our previous positions for us to oppose this. And what Ms. Dosk originally thought would be helpful is that when she is approached or asked for a comment on this, that she has the consensus of this commission to continue opposing that. Is there anybody who'd like to speak on the other side of this issue?
No.
But I'll let you speak your mind, Commissioner
Well,
Cox.
I don't think that we should take the position of if it comes up, because I believe it will come up, and it could come up in the waning hours of the session. I think it's important for us to just take a proactive approach to this and put it out in front and say, you know what, we oppose this.
Any
So it's already
objection
out
to,
there.
understood, didn't mean to interrupt, any opposition to the approach that Commissioner Cox has suggested? Which I think is consistent with us, one, identifying that we oppose this proposal and that in fact we are actually assertively interested in making sure that we maintain the previous standards. I think you've got the consensus that you need on that, Ms. Doss. Are there any other questions from this body on legislative proposals? Commissioner Brady.
Yeah, I would like to suggest, even if we don't put in specific language in terms of a legislative priority, that we do recognize the need for the ethics laws to really apply to a broad range of privatized interests, everything from Enterprise Florida, to companies that really, with marginal oversight, spend lots of government money. And if we don't have any specific language, but I would like us to at least identify this is something we feel needs to be looked at and should be something that we develop some appropriate statewide standards for.
Commissioner Cox.
So I agree in concept to that. In practicality, I draw on past experience where in our county we have an economic development council that is funded, not completely, but probably 50% by county government, and they always struggle with the disclosures of projects that they're working on. And occasionally the press or the public will want to dig into knowing specifics about who is code name XYZ name, who's the underlying company, and they always use the fact, well, you get funding from the county, you should be disclosing these types of things. So I would be very cautious about those types of things, because that would, I don't think it would ever pass the legislature, but I would be concerned that if we were proposing something like that would just give more ammunition there, and in fact, that would be a big detriment to attracting companies and that type of thing.
Ms. Doss.
I have a possible suggestion. During the summers, oftentimes legislative committees will work on interim projects. maybe we could make a suggestion that they look at this issue in an interim project and give some thought to whether parts of the ethics code should be applied to some private entities, and if so, what parts of the code and what entities, and how that would work.
I like that.
probably would be coming after this legislative session, because I don't think they're in a position to take on anything right now, but that might be kind of a move in that direction without jumping off the edge of the cliff.
You know,
I like that because it obviously requires a lot more thinking than we have the privilege of doing in this short amount of time, and even that our own staff has the privilege of thinking about the potential consequences. So, Commissioner Brady, does that meet with your approval?
That's fine.
Are there any members of the public who would like to speak on the legislative proposals? Hearing none?
Madam Chair,
Yes.
do we have to actually vote?
I would ask for a motion that adopts the proposals and priorities that we identified in our discussion.
Okay, so I'll make that motion.
Thank you. Is there a second?
I'll second it.
Any other discussion? Commissioner Norris?
Question, does that include the authorization of Mr. Cason, our Commissioner Cason?
Carson.
Carson.
Commissioner Carson to speak for the.
Thank you. Let's take that separately if we could, but thank you for bringing that up. All those in favor of the proposal, of the motion to support the proposal and priorities as articulated in our discussion, please indicate by saying aye.
Aye.
Any opposed? Commissioner Norris, would you like to address the issue of our legislative liaison?
I would, and I would like to move that we granted that authority by the commission. So that was a second comment about it.
So I'll second it for discussion, might like to amend it.
In doing, if we are to do that, and in doing that, and with great deference to our executive director and seeking in advance forgiveness for additional work, I would like to see a more frequent communication with the board members as to exactly what's going on with those legislative efforts. As you point out, we meet every 6 weeks. I don't think we have to have a weekly video like the Florida School Boards Association puts out, or different things along those lines, or any sort like that. But something every couple of weeks to say, this is what
Transpired.
what has transpired. This is what you sent on old Matt Cason, what he's gone out and done on behalf of, something like that. He's doing that on a volunteer effort, so I hope his efforts are not too much. That's one above and beyond. We probably need to form some kind of a board to get to him if we put too much in that regard.
I have a lot of chocolate left over from Commissioner Carlucci, so
Well, based on your earlier comments, I'm not sure
never,
if that's true.
never mind. Leave it. Commissioner Cox?
Thank you, Madam Chair. I support the motion, having Commissioner Carson be our liaison. It's fitting, given his past employment and also his proximity to the state capitol. I will say this, though, that I'd like to volunteer a little bit to maybe help in the process of trying to identify some sponsors or something of that nature. As luck would have it, I guess, my representative in the legislature is the current Speaker of the House, and also my Senate representative is the majority leader. And I have good relationships with both of them, so I'd like to maybe visit with them with that same authority, speaking on behalf of the commission, in the relatively near future on that. I'd also, if the commission thought it would be appropriate, or if staff thought it was a good idea, I would have no problem in coming and traveling here to lobby the legislature on that, but I would want to be reimbursed for expenses for something of that nature. In the district, no, but if I was going to come to Tallahassee, I would want that.
So at this point, I think the motion is regarding, and maybe we can come back separately to the backup, which is what I think you're offering.
Sure.
If that's reasonable to take up, do we authorize Commissioner Carson to act on our behalf as a legislative liaison? And if I might add, what I think Commissioner Norris intended in that motion is consistent with the priorities and proposals within the legislative proposal that we have adopted today. Is there any other discussion on that motion? Hearing none. All those in favor of the motion say aye.
Aye.
Any opposed? So to Commissioner Cox's willingness to help support the effort, my understanding is that the travel expenses are nominal for coming here, that, and I tell you this because I've looked at it, that the Ethics Commission has the discretion to use funds that are already in the budget for this kind of item. I believe that we have the trust in Commissioner Cox to use those guardedly, and I know that he would. I don't have any question about that. Also, what is important, even more so than the expenses, is that when we have more than one person speaking on behalf of the commission, it's difficult to work with the Sunshine Law and yet still be coordinated in our communications. And so we have to rely on the good judgment that both Commissioner Carson and Commissioner Cox have, as well as Ms. Doss, to making sure that we are coordinated and yet still honoring the Sunshine Law. So if there's no objection to that, I don't know that it requires a motion, but if there are any concerns or questions, those will be well taken. Please feel free to speak.
Does the chair have the discretion to form a committee, if you will, and it might be a committee of two, which would require unanimity on your part to proceed? And again, as well stated by the chair, in accordance with the position taken by the commission as a whole. So maybe that could be done in the form of a committee, and our vice chair, Mr. Cox, could get that to the committee.
Do you know, Ms. Doss?
I do know the commission can form a committee, and it has happened in the past. We can, we can set it up so that it operates in the sunshine. We would schedule meetings by phone, where there would be public notice, et cetera. That it's been a long time since we've done that, but I know that it can be done. Now, sometimes you're going to have a situation where you see an amendment to a bill at 6:30 tonight, and the bill is coming up at 8:30 tomorrow morning. You're not going to be able to have a committee, but in those instances, I'll just pick one of you, and that'll be the one. So, I think that can totally be accomplished. There might be a little logistical awkwardness. With respect to the payment of the expenses, the travel expenses, I think we can accommodate that in our budget. I hope that Commissioner Cox won't be having to schlep all the way up here lots and lots of times. And I think for whatever few times is necessary, we can accommodate that in our budget. I would feel more comfortable if there was a vote authorizing that
Okay.
for him.
All right. Commissioner Brady?
Yeah, I'll make the motion to authorize Vice Chairman Cox to travel to Tallahassee for purposes of legislation when indicated appropriate. I think this is a unique opportunity, really, because simply the unique constellation of who's in the legislature and who is in a position to move things, and Commissioner Cox has a long-term relationship with these people, sees them, I assume, on a fairly regular basis, and this is an opportunity to have someone who they know and trust whisper in their ear.
Is there a second? Can I get a second? Is there a second to that motion?
Second.
Thanks. Go ahead. Any other comments, Commissioner Brady?
No, just,
Okay.
I would also ask that you give me the authority to speak on behalf of the commission. like we have for.
Right, under the
Commissioner
same
Carson.
limitations, so to
Exactly,
speak,
yeah.
that we gave Commissioner Carson. Is
Exactly.
that part of your motion,
Yes.
Commissioner Brady? And do you
Second.
accept that? Commissioner-
Second.
Any other discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes. Ms. Doss, I think, yes.
There's a
Just-
hand.
just-
Okay, Commissioner.
Well,
Brady.
again, did we get the staff, when they have gone through all the reworking of the memo, simply to send the memo?
Yes. And can you also speak, if we should form that committee now, if that's the interest and the will of this commission, that it be Commissioner Cox, Commissioner Carson, and I guess I would participate? Is that the idea? Commissioner Norris, was that your idea of having a committee of 2 or 3? I really don't care. I just wanted to make sure I honored your request.
I think it's the chairman's discretion whether or not she.
I'll leave the 2 of them to it. If they need consults, I'll be available. So,
I saw the executive director as the moderator.
right. So I would ask for a motion just to formally, since we apparently have the prerogative to have a committee for this legislative focus, I would ask that that be made in.
No, she
We're gonna
did.
vote on the one.
We did that one, I think. Did we not vote on Commissioner Cox?
You did.
We did.
We did, okay. I'll move to create a legislative liaison committee consisting of Commissioner Cox, Commissioner Carson, with the chairman as a ad hoc member as needed.
Is there a second?
Second.
All those in, any discussion? All those in favor, please indicate by saying aye.
Aye.
The motion passes.
And also, if I just may add, I think it's a good idea also, just to show that the interests by the commission members themselves, if they're just just one person, you have multiple individuals, and I think that's only can be a good thing.
Thank you. Ms. Doss.
I'm sorry. Thank you so much for the direction. It's very helpful to know where you're coming from. You are much more interested in legislation than many commissions have been in the past. I'm happy to send you updates on what's going on. I just made myself a note to set up an initial meeting of the committee so that everybody can, get where they are. All members are encouraged and invited to participate. Once I condense the recommendations as outlined today into the memo that I usually send to the House and Senate staff, I will send it to each of you. If you know a legislator, feel free to slide it under his door and say, if you're interested in promoting some good public interest legislation, here's a great opportunity to do that. So all on the same team here, and I really appreciate your vigor in all of this. Given the discussion, I kind of feel like with the committee that's been set up, we can figure out the direction, and do we need to write letters to the editor, whatever, we can get that worked out as we go along. Thank you so much.
Madam Chair, on that point of writing letters to editors, and I think someone mentioned, executive director mentioned press conferences, I do think that advocating our opinions on this should not be confined to this room or anybody that takes the time to read our minutes or review the film. So I don't know if we need to have a motion on that, or if that's just through the normal course of what we're doing, but, a letter that's signed by the chair, I think, goes a long way out there.
I think that we can take that up issue by issue and action by action as it becomes necessary as we move through the process, and I'll be happy to be responsive on behalf of the commission, as you've indicated you want to be through our discussion today. Commissioner Berger.
I just wanted to add a comment. In reading through these 30 pages, and it's my first year reviewing this, today we've identified and prioritized legislation that is for the good of the public and would benefit the public. And I think that in seeing how long some of these ideas have been around, I think this is a great idea to get organized in order to help implement these potential steps.
I agree. Thank you, Commissioner Berger. Ms. Doss, do you have any other part of your executive director's report you'd like to share?
I do not.
At this point, I'd entertain a motion to adjourn the public session. Excuse me, go ahead, Commissioner Cox.
On the executive director's report, you know, since I've been here for a few years now, the status of these probable cause hearings that involve members of the legislature or they just keep hanging out there. You know, the one back from 2010 regarding Jim Norman from Hillsborough County. You know, that's the county right next to ours. It was all in the paper there, and the fact that this is just sitting out there waiting for the Senate President to do something about it, and then there's 2 cases pending for the Speaker to take action on, or the House to take action on. I believe that we're a little bit derelict if we don't write a letter to the appropriate individuals saying, you know, my statute's supposed to do something about this, so please do it, instead of it just sits here meeting after meeting after meeting on our report. So I would like to see us try to proactively get the legislature to take their required action that statute says they should do.
Mr. Anderson or Ms. Doss, do you have any comments on that? Otherwise, I would entertain a motion that we at least make a status inquiry with respect to those pending matters, particularly those that are more than 5 years old. Well, 3 years old. I'm just picking a random. You can, whoever makes the motion can pick their date, but those are older. Any objection? It doesn't even have to be a motion. Any objection to sending a status inquiry on those pending matters? Thank you for observing that. That was a good catch.
Thanks. I read the agenda.
I read the agenda, but I didn't read the date.
Well, that one
Those
just
are
pops
good.
up because
Those are-
it's you know, known to me. You know, I don't know that any of us were around when these cases were heard,
point.
but
Like our good friend David Rivera.
Good point.
2009.
Thank you for bringing that to our attention, and I do think it is part of our duty to at least follow up and make sure that it hasn't fallen through the cracks.
So I make a motion that we adjourn the public session.
Is there a second?
Second.
Any objection? We stand adjourned. Thanks. We will reconvene at 10:15.
Commission, 400,000 person.